everyone, this is Thoughtful Thursdays by Tornado IP, and I'm here again with Mike Bowe, and we're talking about how experts read patents. And we started 2 short sessions so far. We were digging into the Ozempic patent that is an important foundational patent for Ozempic, and we took a note of it because Ozempic accidentally forgot to pay their maintenance fee for the Canadian patent family member. So we looked up this patent and we utilized it to just show you a little bit of what you would need to know to take a look at the cover page, what you can learn from a cover page of a patent. And today we're going to continue this conversation, and we're going to talk about claims. Claims are everything. It's really the deed to the property. And one of the reasons we are doing this set of episodes is because a lot of times when we first start working with new inventors, they are really overwhelmed with patents because they're just reading. They feel like it's so much to read. But really, there are some quick things to look at first that can tell you a lot about a patent, and you don't need to read every last bit. So once you took a look at the cover page, based on our previous episode, we would next jump to the claims. Based on the cover page, you decided that yes, this is indeed a patent that's important to take a look at. That will be the next thing to look at. So again, this is the most important part, and they're not at the front. So after the front cover page, there's a whole lot of background discussion, and so that's not, most people that get overwhelmed by patents might never even get to the claims. So this is kind of why we're really emphasizing this. Like, the really important thing to do once you looked at the cover page and you learned what you needed to learn: is this patent enforced? Is it an application? Is it a grant? What's the company that's assigned to? What is the approximate filing date, expiration date? You would want to jump right to the claims. This particular patent is 70 pages long. If you're looking through the description, there are 40 plus peptide sequences that are just described. And by the way, the description of the patent, there's no legal requirements of how long or what you can and cannot put in there. There are some requirements. If there's some weird term in your claims, you have to explain that in the background. But other than that, you can put your bedtime story for your children in the background, and it's fine. So sometimes it is a strategic decision to disclose some information that's relevant for a totally different invention, just to have it disclosed somewhere in some middle of a page in page 13 or something. That kind of thing can happen. So being able to search and knowing how to search when you are dealing with patent questions is really important, to find random hidden things like that. But for the purpose of understanding what a patent's all about, you just need to jump right to the claims. And that is because that's the only legally enforceable part. So go ahead, Mike, you want to go cover this one?
Well, I often go to the claims first, also because it gives some idea what I'm looking for if I want to go through the body of it, right? So is this a compound, or is this a method to do something? That sometimes is a bifurcation that's useful to find out from the claims. Or, and it often happens, a compound such that, and they'll have some claims on that, and then later claims will be a method of doing something that uses a compound of claim number 1 through 5 or something like that. So, but it tells what you're looking for if you're going through. It depends on what I want to do. If I want to say I have an idea of either a compound or a method I want to practice, I'll look at the claims and try to see what does that fence line look like, and does it interfere with what I want to do? Does it get close to it so I have to be careful, or is it actually quite far from that? So that often can tell you how closely you want to read the rest of the patent or not. There is a requirement that you disclose how to carry out the invention. So that has to appear somewhere in it, but you don't have to say, this is the exact best way. You have to have it in there, but you don't have to necessarily have to highlight it. So you can't just make claims without any kind of context for it. Trying to think of what else is relevant. As far as looking at the patent itself, the prosecution history you don't see there. You see that in the search, whether it's a search tool or at the patent offices, you call it the file wrapper. You can see what were the original claims in an application and how did the patent office argue that, oh no, that's not inventive, and then how did the inventor say, well, we think you didn't understand. Seeing that back and forth could tell you a lot about the direction they were pursuing. So that's the advanced lesson, I would say, of looking at them or failing to do that.
I would say a beginner mistake, description equals coverage. It's because some people really, like when they first are working with patents, they think of them as scholarly publications. And like if somebody wrote a paper about something, you want to read the paper, but and then they assuming that whatever is in the paper, that's what it covers, which is the truth for like a journal article. But in the case of a patent, the enforceable part is always just the claims. So in this particular patent, Claim 1 and Claim 3 are the independent claims. So what that means, when you have an independent claim, there's a bunch of patents, and it's kind of like a funnel that depend on them, that get narrower and narrower and narrower. And so the independent claim is the broadest possible claim that with its type in the claim set. So those are the most relevant for you to understand if you want to know what a patent is claiming. So go ahead, Mike. You want to go ahead and talk about these two independent claims?
So they're very specific. There's a single compound, and they have, I think you showed it earlier in the slide, that there were maybe 20 pages describing here's what peptide sequences are. And they give a whole series of peptide sequences. And the claim is only for sequence number 7. So just because they disclosed these 40 sequences, and it could have this and this, the qualities, hydrophobicity, etc., it's the claim that they're able to prevent others from doing is only that single one, number 7. Well, I'm curious what that is. If I knew peptide chemistry, which I don't, I could go up and see exactly which one they did claim. And if I'm curious, why did they only claim that? Is that the only one that works? Or is that the only one that the patent office allowed, and they actually had initially tried to get a much broader array? That I would go back to the original application, which would have had that. Maybe a larger set of claims or a more expansive set of claims. So that's how I've discerned those.
Mike, it could also be that the patent examiner said that you can't claim all these 25 peptide sequences, you must pick one. They could have required them to do that.
And then, but it's not just a molecule, it's a method of treating by administering this. So that's, I think, interesting, and that's frequent to see that kind of structure. That is some number of compound claims and then a method of what this compound or material is actually going to do. So, and I don't know if I'm getting ahead of other things you have, but somewhere in the body of the patent they say this compound can be used for a number of medical conditions, but Claim 3 is treating type 2 diabetes. So, although we in the news now see Ozempic also as an obesity drug, whatever this exact compound is, they only make a claim for it treating diabetes. So just because it was disclosed up front in the top of the patent, the claim is the only one that you can prevent someone from selling it for. And it also prevents you, I think, from marketing. So you can't sell this labeled as diabetes treatment without the permission of this patent owner. I think it's not as though if you're not giving the drug, you also can't induce someone else to use it for something that's inside this thing.
So Mike's comment is that in the description, these sequences are also described for use for a number of other medical conditions, right? And again, if the background of the patent, you can disclose whatever you want to disclose. I would imagine that if I came up with a compound that's really great for diabetes, but I haven't been testing it for other medications, that's a huge amount of work to do clinical studies in other medical ailments, I might want to disclose, though, that there's a potential for my sequences to be used in cardiac problems, in arthritis, and whatever else. I could just dump that all in there, and what that does, it would prevent others from claiming that, so that at least, even though I don't have a claim on it, I can stop others from being able to publish it as a patent, try to patent it as well, right? Next, so again, a little bit more independent claim, the broadest and standalone, and then the dependent narrows and provides a fallback. For example, like in this case, the first independent claim, and we'll show you in a minute, gives you the sequence, the peptide sequence with some molecules, functional groups hanging off in different ways. That's your narrow molecule. But then the dependent claim might be a compound in a specific salt form. So if, as you're looking at a patent claim and you want to know, am I going to be able to make a molecule and sell it? You want to be outside that claim one, for this particular patent in order to be able to practice and not infringe. Fewer claims, not weaker protection at all. Like if you have fewer claims, sometimes it can provide very robust protection, right, Mike? Any other thoughts on that?
Yeah, I think this one is interesting in that it seems to be it's a single compound, but many times a claim one compound is broader, right? A polymer of this ranges, and if it encompasses everything that the inventors think is doing what it's going to do, it could be good enough. Or it may have stuff way outside it that's impractical. Okay, then you're not losing any protection that's really going to come up. So you don't need a ton of claims. Often it's the first one, and then the narrowing down ones sometimes get closer to. But if the first one is valid, then that covers it all. So you don't need 50. Sometimes you do see that, but you don't necessarily need it for a good one.
Yeah, and in fact, you're going to have to pay more money if you have more than, I think it's 20 claims. You have to pay more.
Is that right?
Yeah, from what I remember. And then also sometimes if you are trying to cover too many things, the patent examiner will say you need to split up your patent and create two separate patents, because you shouldn't be covering two totally different inventions in one patent.
Mm-hmm.
So here you go. Here is the first and the third claim. Number one here, you can see compound of the structure. And you can see this EGTF, these are all amino acids, so the sequence of amino acids, that's your peptide sequence. And as I mentioned, these are different functional groups hanging off of that peptide sequence. And then in claim 3 is the method for treating the type 2 diabetes in a subject. I said method comprising administering the subject in need of such a treatment an effective amount of the pharmaceutical composition comprising a compound of that very same structure.
Yeah.
This EGTF is very same compound. And this is your sequence number 7. So here's what I mentioned: when you say something like sequence ID number 7 in the claims, you have to explain what that means. It's okay, but average person, even somebody trained in the art, doesn't know what sequence number 7 is. It's not something you learn in biochemistry class. So the patent attorney and inventor would have to explain what that means. Mm-hmm. Any other thoughts on that part, Mike?
One might look at this and say, I've been doing research on pharmaceutical candidates, and it's not exactly like this. But that just means that you would not be infringing on this patent if you tried to do it. But that doesn't mean, and then we'll do this in maybe future episodes, there could be a whole body of parallel patents by this or by other inventors that would claim, and they could be valid, they would claim compositions that do cover your intended research material. So seeing something doesn't show up in one patent doesn't mean there aren't others nearby. So if you're interested in the field, you have to pay attention to them all. Exactly.
Broad versus narrow. Sometimes we'll say we have a nice broad patent versus a narrow patent. And we were explaining how in the case of this particular patent, they had like more than 20 sequences in the background, and very likely, like if you go in to look up the file wrapper and the original application, they probably claimed more than one sequence. And so you would say that's a really broad patent claim. It has 20 sequences in it. In this case, they narrowed it down to this one sequence. So this is a narrow by design, and in a way that's sometimes better because it's harder to attack and easier to enforce. It's very, very clear that if a generic manufacturer manufactured this exact same compound, there's no doubt that they would be infringing this patent claim. So what a granted claim does not tell you, Mike. You want to take this slide?
Yeah, so as we just saw, there's a compound that can be administered, and it's a method for treating diabetes, but that doesn't mean that the material that you're getting from your pharmacist or doctor is completely described by that claim or the 60 pages of text above it. because the drug could have other things. The drug or in this case, a drug could have other materials, something to make it more soluble, make it more stable, shelf stable, that it's okay storage at room temperature. All kinds of things can be in a product formulation, and the patent doesn't prevent those. Like the patent says, would allow you to have those or not have those. All it requires is that one sequence 7 material and a method for treating a patient with it. So it gives you some hint that compound must be in it, but there could be others, and that's not disclosed in the patent. So it's not a total intelligence package to look at one patent, even if the drug might say on the bottle, made under this patent. That's not enough to tell you everything that's in there.
Yeah.
And I guess in some of the other points, I'm just looking at the third one. Okay, you get a drug from that pharmaceutical manufacturer. That doesn't mean it's exactly this one that's working. That was one we got a patent on when we applied and it was granted, but we may have improvements upon that are patented, or maybe we kept them secret and no one knows about it, that are better, but they're the ones that we actually put through the FDA and other countries' approval process. So a patent tells you what they were thinking at the time, but it's not necessarily a guarantee that that's what's in, again, the material that's sold and used in commerce, a drug or otherwise. Yep, so those are some things to be alert to, that again, a single patent is not a one-to-one correlation to the material that's actually being used, or the method that's actually being practiced.
So the description tells you what they built, and the claims tell you what they own. And what we mean by that, tells you what they built. A lot of times, and I don't want to discard the description that I don't look at it at all. A lot of times you absolutely need to look at the description because it gives you some explanations. You know, it like much more carefully probably explains that sequence 7 that you can really, really see. And if you're trained in the art, you should be able to reproduce. And it always usually gives examples. In most countries, you're required to have examples of how you reduce the invention to practice. And sometimes looking at those examples is necessary to really figure out what those claims, the patent claims, were saying, because they're not necessarily written in a clear way that is clear to you as a scientist or as a patent attorney to really understand. So looking at the examples is usually very, very helpful, and that's in the description, how they built it. But the claims are more important in order to understand what the company actually owns. What can they enforce? If you did whatever is written in the claims and you infringe, they can sue you. So, as Mike keeps on saying, you know, one patent is just one patent. It's not exactly tell you what everything that's going on. It's just one data point. So, one quick and easy way to start getting a feel for what else is out there is to look at the citation, because usually a patent cites other patents that came before it that is related art, and if a patent is a good, really interesting innovation that's gonna make money and it's valuable, it gets cited. It's not any different from a journal article. If you really came up with something clever, people are gonna try to work off of your invention and innovate, and that really is part of patenting, that you should disclose what you did so others should know, and people trained in the art could further innovate, you know. So really that patent is only enforceable for 20 years. Part of that is you publicly disclose it, and further innovation can be possible. You can protect what you did for 20 years and make some money, fine, recoup your R&D efforts, and some in case of Ozempic, but others should have awareness and they should cite. So as a result of this logic, you should be able to see some really interesting things about the patent landscape by who's citing it. Very clearly, Novo Nordisk is one of the first companies to be in this space with this type of molecule. Well, very obviously, most other big pharma companies and generics would start quickly to look at it and say, how can we reproduce this, make this better, make it more stable, make it into a tablet instead of an injectable, all kinds of ways they can innovate and make a product that will be outside the claims and will be innovative and can be patentable. And that's the kind of thing you can see in patent citations, and patent citations of an important patent will be numerous, as you can see here. just wanted to highlight again, Tornado IP is here to help you. If in your space you want to do this kind of exploration, Mike and I would be very happy to help you. Schedule some time with us for an intro, and take a look at our website, tornadoipconsulting.com, where you can schedule time. But we're very happy to consult and help you with this type of investigation and come up with approaches to protect your market. So we're going to move on to the citation piece. Who's watching your patent? So this particular patent was cited 255 times. That's like enormous. You know, most patents that in the chemical manufacturing, electronics space, if something is really innovative, it may be like 30 to 50 times. 250 times, that means this is a really, really important, significant patent. Again, a patent citation means that somebody says this came before my invention. Backward citation, that is what you're citing when you're filing a patent application. You cite things that you built on. Forward citation is who is building on you, who is citing you. And again, citations is competitive intelligence hiding in plain sight. Any other thoughts on that, Mike? We're going to dig into this for the patent.
For in this case, say it was first publicly knowable in 2006, published, granted in 2012, and so in that 1 to almost 2 decades of others being able to see it, I also am curious to see, of the many future citations, how many they themselves are granted, because that means now there are more property line states, some overlapping, some adjacent, some far away, but that'll give also a feel for how much more invention there was to be made after the time of this. And then we'll look at the assignees and say, oh yeah, we're certain that a fair number are going to be novo, but who else? So, and you mentioned it here somewhere, who else are the players? And so that's all findable by this citation list.
So this particular patent cites 44 other patents, some of it as old as the 1990s. So that kind of implies that probably some of this chemistry Novo was already looking at. And half of it cites back to Novo's own patents. It's very likely that if a chemical compound is successful in humans, it's not damaging, and some of the clinical studies show that this works, they will be investigating and continuing to innovate of how they can use this compound, and that's clearly happening here. And just highlighting again that some of those older patents might have been not granted or withdrawn, or they might have expired, but they're still relevant prior art. So when a new patent application is filed, you still have to cite that. Yeah, and does these kinds of roots tell you how crowded the field was? Any other thoughts on cited things that you have to cite, Mike?
No, there is a requirement at the time of filing. You can't just file and say, I have this invention. You're required to cite the nearest back prior art. And even as a check on that, the patent offices have pretty good searching tools also. So if you know of something that's pretty close, you have to disclose that. Now, you may have missed something in the search, and that's why they also do one, but it's not as though, well, I only want to disclose a few things that are older because I don't want to make it too easy on others following me. No, it's a requirement that you say, what's the nearest prior art? So that's part of your application process requirement, is that you honestly say, here's what I think is closest.
So what do you think? And one other thing here is that it's not just you. The patent examiner also will do a prior art search, and they might find additional things that you didn't know about, and they will cite that against you. So it's usually not the best idea to be in a position where the patent examiner finds patents or publications or prior art that you didn't know about, because a lot of times then you'll have no options of how to shape your claims a little bit better to still allow it. A lot of times that can really hurt the process, and it can lead to just not allowing claims and maybe even completely rejecting some of your key claims. And so, yeah, I've heard some companies sometimes have a strategy where they don't do any prior art search, they just file lots of patents. I don't think that's a good approach. Mike, what do you think of that?
It's not a good approach. It's funny, that seems, I'm going to say archaic, but my gut feel was 20 years ago when maybe either the searcher or the search tools of small to even medium and bigger companies were not as good, and you honestly did miss some, and the patent office was better. So some would say, oh, they'll find the stuff that you missed, but now you really do have access to finding all the relevant prior art. So I'm not as aware that that's happened so much in the more recent, say in the last 10 to 20 years, but when I first started longer ago, it would be not unheard of that you get a surprise. They found this and this is really close. I wish we had known about this, but our searching quality was not as good.
Yeah. So forward citations, it's really the competitive radar. If you have this many, 255 citations, that tells you, in the case of this patent, that many others are probably looking at the same molecule. Their applications continuing to file, even in most recent 2026 we see site applications. So basically the message is that 255 teams thought that this patent was worth referencing. So what do forward citations tell you? Here are some of the things. Mike, you want to go over this?
So again, and you can often, some of the tools allow this. You can almost pluck the information out and graph it yourself, but they allow a graphical depiction of it. So who's got the most, the second most, the third most of the assignees, or you can do it by inventors also if you want to do it that way. Also, you can do it with your x-axis as time. This person had a big 5-year flurry of filing things, but they haven't done anything in the last 10 years. So they were interested in, either got out of it, decided it was too crowded, or they are not as expert. For whatever reason, it doesn't tell you that, but it tells you what their interest is in time. You had a brief mention on the prior that up until 2026, there are still forward citations of this original 2012 granting. So it's still relevant enough that people today are citing it in their applications, if that's when it came out. And you don't get it as much from the PDF of the patent, although Google Patents has this, I think, the maintaining of them. That is, okay, people got patents, a number of these men had been granted 10 years ago. Did they keep them all alive or did they let them go? That's like all the landscape of what followed this, and then whether it kept going, whether it petered out, all that kind of stuff. I like even just the list of forward citations without going in and reading them. You can see a lot of that.
Yeah. And I think in terms of, I'm thinking about if, let's say Novo were to engage with Tornado IP to help them, and let's say we don't know this space at all. But first thing I would do is take a look at some of their foundational patents, and let's say nobody in their IP department is talking to us. I would find all the patents with the most number of citations from Novo in the Ozempic space. I would take a look at who's citing them. That would allow me to identify the key players in the space, and I would look at their most foundational patents, and it would start to give me a picture of opportunities that are people innovating towards, and like a few of them I already mentioned. I am sure that they are innovating towards how to make this compound a tablet, because it's just injectable, and know that everybody wants a tablet. How to make it temperature stable, because the original injectable is for sure you have to refrigerate, and in order to get pharmaceutical compound to your audience, you're way better off if you don't have to refrigerate it globally. So some of those things, even if you don't think of, just pop out at you in this kind of an analysis of the competitors. And then you can bring that back to the Novo team and say, hey, these are the ways that your competitors and customers are innovating, because they're going to see some of their customers also filing, and that can be the foundation of a strategy for how should we move forward, how should we invest our R&D dollars to innovate in ways that we could do better than the competition. So here's one that Mike picked out from the, I think this is, one of the citations. You want to talk about Aegis Therapeutics, Mike?
Right, so I just noticed that in the long list of future citations, there was a block of them with Aegis as the assignee, and what are they doing? So you can go in and look a little bit, and it says, stabilizing, all right, compositions and methods. So they are interested in making stable formulations. They might not want to make the active, if you will, but they either formulate and or attach stuff to it. So it's almost like they were making the original material more useful, more in some way, or more valuable, and that was their angle. And you can't deduce their strategy from it, but that might have been technology that they could license or sell to someone who makes the original compound like Novo. So that might have been their interest. And if it's stabilizing compositions, it could apply to stuff besides this drug we're talking about just today. So that might be more broadly applicable. And so now that's an interesting. Again, you want to look at the exact words of the claims, but it might be something that could stabilize multiple different drugs. So that's interesting to me in that maybe that was their expertise at first. Maybe they thought, we're not going to make it better active, but we'll find ways to make it work better, last longer, whatever. So
Yeah.
I thought that was a cool way that they had a strategy that was adjacent to the existing material.
And who knows, it could be Novo since then bought them or is licensing from them, but that's not always as easy to discover. You might have to do some additional digging to find that out.
Right, that might show up in say the actual formulated drug approval process, although some of that might not be laid public necessarily, but that could be something that ends up in the material when we talked earlier about the actual drug you take might be whatever's in the original patent plus other things, and they themselves could be patented and could be by someone else. So it's it really is an interesting, complicated web, I think you called it.
Yeah, this is something like if they were to acquire a tiny company like this, Aegis, Novo, they might not change the assignee name on those patents actually. So where would you discover that? You might discover it in the public reports to their investors. They might have like a few years ago disclosed that we acquired this company, Aegis, and that's public information too. So, but you need to do that kind of a searching to discover what exactly happened to Aegis if it was really valuable. So, what to do with this? Clearly, this is really, really important information. Who's citing your patents, and really great way to make sure you don't lose sight of this is to set up alerts. All of the search tools that I mentioned that you get a seat for a few $1,000s a year allow you to put in a patent number and ask it to send you alerts. And you can set it to like once a month, send me email if anything changes, if citations are added, if it's an application only, like if it grants or anything changes in its status. And then you get an email and you find out who is starting to be active. Is there something interesting happening that you should know about? Again, it's important when you're monitoring your citations, the forward citations, to look for things like what Mike just demoed in Aegis, that the same assignees, some time frame, they're doing something strategic. And that might be something to bring back to the team. If we were working with Novo, we would go right back to Novo and saying, hey, what happened with Aegis? And I am sure they would have looked at Aegis, and either they would have said, oh, that's just useless technology, or we have something way better than that, or if it's really, really good technology and they really needed it, they would have had a license or purchased it for a big company like that. So citations don't just show history, they show who's coming. And the next episode, Mike, do you want to move on to the next episode today?
Yes, sure.
Cool. We're going to talk about the landscape, why one search is never enough. Mike did a fantastic demo on searching, and again, same thing as you have a problem with when you're moving from an academic world and you're reading articles to moving into patents. You have to really adapt to how you read and review and what are the things you're looking for to be efficient. The same type of thing also happens when you're searching and you want to answer questions around what's out there in the patent space. It's very different because patent language is not as standard as research language. Usually people work in one research space, they have some of the same languages, they have some of the same, they know who the famous professors are, and you search for them and you can pretty much find what you need to find. But in patent space, that's not the case at all. You're going to have different types of synonyms for the same thing, and so you have to be really careful and not make assumptions that you put in one word and that's enough and you're done and you did your search and did a good job. So ultimately, I remember one of the patent attorneys that we used to work with early in my career, and I know Mike, you were involved. He said that in order to have a good patent, you have to have an inventor, a good inventor, you have to have a good patent attorney, and you have to have a good searcher. because all of those things, doing a thorough search to really understand what's out there in the space you're innovating, really teaches you to draft really good patent claims, and for the inventor, teaches them how to get clever and innovate. So one search is usually never enough. And again, we're happy to consult with you how to do your search and how to like really understand your patent space. With Tornado IP, we do IP pulse checks, identify top 10 moves, assess your competition. Just find us through tornadoipconsulting.com. There's a place where you can click and schedule a 30-minute chat with us. So, landscape. Why one search is not enough. How experts read patents. We're moving on. And so, these are numbers. So Mike actually wanted to demo this, and he did a search on one topic, and he did it 4 different times. And the first time he did it, he found 907 patents, then 456. Then he did, and he found only 96, and then he went to 2796. And it's all in the Ozempic space. So like we were, still focusing in the same area. And Mike just wondered, what would I get if I did a search? It's the same question for answered, and here's why that matters. Here you go, Mike.
So the search tool has various degrees of richness. If you're just looking for a word to be in it, okay, the GLP-1 family, just searching for that, and there's some number of hits, 900-ish, but this is now in the news as an obesity drug, although it seemed like it was first diabetes. So did anyone mention obesity at all in the language of the patent? Well, yeah, it turns out half of those original 900 that I found did. Now I'm looking to find them both in the claims. Just because you mentioned something in the description, if you're really trying to stake a claim to the use or the compound, whichever it might be, it has to be in the claims, and so it's more likely to be something relevant to that. It's going to have it in the claims. And so, again, I'm using the word GLP-1 and obesity, and so now you're down to under 100. You could potentially read the titles and abstracts of those. That would be a harder thing to do for 900 or multi-thousand. And then this was for, this is in reverse. So these were all ones where Novo was somewhere in the assignee, and again, the company's name is Novo Nordisk, but I just used Novo, so that might have found something. If there's another company, Novo Holdings or Novo something, it may have. But when you don't restrict it to that, now there's 2,700 plus hits. It gives you an idea of what the filtration or widening of your search can find, and what are you really looking for. So
GLP-1,
a single search, you find, so it's now 100 up to almost 3,000. That's the breadth of numbers just in that simple.
Yeah.
I wonder what this can do inside a Google patent.
So GLP-1 and obesity without Novo gave you 2,796 hits, Mike?
Right.
Wow, that's a lot.
Right.
So yeah, you want to continue on this one, the illusion of a simple search?
So again, I would sometimes like just string the words together there's the simple Google patent search on. In fact, you do it in Google, sometimes it gives you the patent, or more often it'll give you whether it's popular news articles or advertisements. So getting into a patent database, a single word is not enough. It's really if you could narrow it down more, but you got to be cautious about that because, and I think you highlighted this in one of our earlier chapters of this whole discussion, obesity, but also appetite suppression or other. So the language used and the language changes from country to country maybe, or over time might vary. So by saying I'm looking for obesity treatment drugs, and if you only look for the word obesity, you may miss stuff also. So you've got to be, and there are multiple technologies, even simpler ones, polymer or plastic, or macromolecule. All of those could be words that are important, and if the author didn't use them anywhere in the patent, then you would miss that, even if that's the way they describe it inside their company, for example, and it's legitimately defined inside. So this is the case. The language, the search tools are pretty good on language, but they don't guess what you're not asking them. So
Yeah, and a lot of times what you do is you learn what the synonyms are, and by doing
Right.
iterations of searches. So you would look at Novo's patents and you would see what synonyms they use for obesity. And if you didn't realize one of them is a synonym, you start a little document and you start putting all the synonyms in, and then you look at Eli Lilly and you look at other competitors, and you're going to find that their patent attorneys might want to use some different words, because why not? They don't want to be easily findable. So I would imagine that with the advent of AI, like there's definitely AI bots within search tools now, like Orbit definitely has an AI bot that'll help a little. They will help design you a search strategy for you, but you still have to have awareness of that and take a look at that. And if there's something that's missed as you're reviewing the patents of the different companies, be aware that it's very likely that the synonyms are going to be slightly different, and try not to miss things. Okay, so why the numbers change so dramatically? A little bit more, like Mike was saying this already, but emphasizing again, the full text versus claims, like obviously many companies would disclose obesity in the full text about a lot of different similar molecules, but they might not all claim it because they would have to do experiments, reduce it to practice, show some method of administering to patients. They are not going to do that for lots and lots and lots of different types of ailments. So they might have it in the full text, but not in the claims. So the claims always, when you're searching just in the claims, you're going to have a smaller set of patents. So if you're just, let's say, again, Mike and I are working for Novo and we're trying to figure out what's going on, we're not going to look at 2,700 patents. We want to narrow down to the most important ones in a space. A good way to do that is just to look in the claims and like which patents mention this innovation in just the claims. Those are going to be the most important patents for us to understand how the different companies are approaching it. So that's, it's good to be able to narrow down so that you don't get that many. And then the second way to filter, let's say the original set was 2,700 and some patents, you definitely, based on your citations, you should have a feel for who are some of the main players and start to narrow in on those. Okay, so if I know that Eli Lilly and Novo, and I think Pfizer is in the space now, who are some of the big players in the space? Let's just narrow in on their patents and let's understand the 5 biggest players. That's another thing to do. Certainly citations, you can look at what patents are really cited a lot. That's another way. Like I don't want to just tell you to do SINE filter and pay attention only to the most important big ones, because there might be some small companies that are doing some really cool things that you don't want to miss. And then, as we just mentioned, pay attention to the different claims are going to have all these synonyms, and you're going to have to just make sure that you're not missing it. Because every filtered decision changes what you see and what you miss. What claims only tells you. The claims only search are, again, what companies actually own, not just what they mention. So when you're searching in the claims, you get gain in a precision, not loss of data. Again, it's because if it's not in the claims, it's not protected. Anything else I missed on that one, Mike?
Not there. I find it, I usually haven't had as big as the Ozempic field, but others where, say I'm doing my first shot at competitive intel, and it's a field that I've not exactly, been sunk into for years, I'll just try to find a couple close patents to the area of interest, and I'll read them in a little more detail, not because I want to know what they're doing, I just want to see their language. So again, I came from the materials, buildings, and polymer world, and so how do several different people describe it, just to see that you're not missing a description of energy, efficiency, insulation value, right? The couple, there's, again, linguistically, they could be different enough from each other that you wouldn't just get it by spelling variations. And just like you might browse a couple of reference books on the topic in a library, that's a way to get it. Just try one more. Now, if someone's making an insulation product and doesn't mention insulation, that would be a little shocking, but I often would do that with just a couple of close hits, just to tune up my language, and then do the search that I would call the more thorough one.
And again, I don't know, I haven't used the Google patents extensively, but if you're using one of the patent search tools that we're mentioning, you can definitely OR together a bunch of different of these terms. So once, let's say you are living and breathing in the Ozempic space, you will have a list of like 10 different synonyms for obesity, and you will OR it together, put it in parentheses and stick it in there, and then whatever chemical compound you're interested in, and you build this type of skill set as you work in a space, and we're happy to teach you how to do that, but it's very important because you don't want to miss things. So 2,796 results, dozens of assignees, hundreds of filing dates, multiple countries. This, I mean, it's scary. That's why we started narrowing in and giving you suggestions, because that's what we would do. We would start like, okay, let's look at the most important stuff. That's the most recent. But even with help from AI, which these days people do use AI for this type of analysis, the analysis could take weeks, if not minutes, because you don't want to miss stuff, and you have to ask strategic questions and come up with the filters that you want to do strategically. So landscape analysis is a discipline, not a search box. And also like your original set that you start with. Again, you have to be really clever and go back and forth a little bit with your terms to make sure it's a correct set. When you're doing landscape analysis, absolutely, you don't want to miss those synonyms. Then totally, because what that could happen if you miss a synonym for obesity in this case, you will totally like ignore a company like Eli Lilly because they use some different like BMI index, something like that. If you don't put that in there, you don't find any of their patents, and that's a main player. But guess what? Their patent attorney is clever, and they decided not to include obesity in their claims. It wouldn't be the first time that something like that happens. So being strategic to come up with your original set, and then spend the time to do this analysis, it's really well worth it because it's the foundation to find opportunities and gaps that then you can streamline and come up with a strategy of what's the best approach for you to protect your market. So what a real landscape looks like. What are the kinds of things typically that are popping up, Mike?
Again, it's the players, and sometimes you see these in like 3D plots also. Who's doing what over time. Also, sometimes there are numbers. So if there's one company has 30 and one has 3, that's you might weight those differently. Not that somebody with a small number of patents is not to be considered. What are they claiming? Are they claiming treatments or are they compounds? So that like sometimes is a split people do. I'm interested in ways to stabilize or to make as opposed to the treatment that you'll do with it, as opposed to formulations of. So you might sometimes split them that way. So that's all part of the landscape, and you can either line them up. Again, some people do make it like an actual contour map, and then also, people get patents, but do they keep them for the whole 20 years that they could? And that's by maintenance fees. And so you look at that. If somebody got them and they got rid of them, they must have, in the time between filing and granting, learned it's not so useful, or it's not so useful in the countries that they had originally been granted.
Yeah, and again, that type of information definitely comes out in the paid-for patent tools. They definitely have information that's mostly accurate on is a patent live or dead? Has it been maintained? So one search gives you a data point, but a landscape gives you a map. So that's kind of why we are here, broadening out. Originally, we're just looking at one Ozempic patent, and we were telling you how important it is to not stop there. If you really want to understand what's going on in the space, you really need to broaden out and look at the citations and then end up with a larger search to really understand the landscape. And the reason you want to understand the landscape is to be able to build out a strategy, a patent thicket, an IP strategy where you can protect your market. You build out a moat. Again, this is what Tornado IP is here to help with. Our specialty is IP strategy, helping with assessing where you are. It's not only we bring you the expertise of how you read patent and assess things, but we also bring the expertise of a different mindset, a different technical expert taking a look at your space. Often will ask some questions that you wouldn't have thought of, and that can always reveal some new innovation opportunities. So please find us at tornadoipconsulting.com and schedule 30 minutes to chat, and we're happy to help you. So the last segment of our How Experts Read Patents based on the Ozempic patent is is the patent thicket, how companies build moats. So, hopefully by now, like we have learned that it's one drug, very many patents, dozens of patents, different expiry dates in every country. It's very likely that Novo protected Ozempic well beyond the molecule itself. And so what is a patent thicket? It's a deliberate strategy. It's not an accident. We layer patents on the molecule, the formulation, the delivery device, the dosing, new indications. Each layer starts a new expiration clock. So just because the molecule expired and they forgot to renew it in Canada, maybe they also had a formulation patent. Maybe they had a device, their injection device of how it's injected. All those things still protect, so maybe they could just let go of their formulation patent. Who cares? So, and that is intentional, and it costs money because filing patents and writing patents and doing the experiments of the patent costs money. But the intention is to have multiple patents that are innovative and that protect what you're doing, and to make it nearly impossible to have a generic, even when the core patent that expires. So there was one compound patent, which was a molecule that we saw, but based on the citations, about half their citations are forward citations are themselves. Novo didn't stop innovating in this space. They knew they got to something really good, and they kept on innovating, and they keep on innovating around the formulation spends, the weekly dosing, cardiovascular use, weight loss indication. So all of these types of patents extend the protection to 2032 and beyond. So losing one patent just never removes one. It just removes one lock, basically. Mike, do you want to? This kind of just keeps on emphasizing this. Do you have anything else to add?
So we did the first one, and then there were some improvements. Okay, there was a molecule. They defined a single molecule in the patent example we used in the last few chapters. That doesn't mean there's not improved ones in subsequent patents or simultaneous patents. So. And then treating a disease, but then again there could be others besides diabetes, and I'm pretty sure when we look through we'll find those, and then all the other elements of it. Can you just take this, did they find an inventive way to combine this with another drug, just like I'm thinking of the MMR vaccine is 3 combined? Is that potentially, although the individuals may be on old patents, the combination of them that's stable and better and not obvious, if that's the claim that was made to the patent office. So there's a lot of combinations of them. There's not much else you can say other than whatever you want to really give. A single one patent dying of old age does not mean the commercial material is not still exclusive to you.
Yeah, and also I want to emphasize that IP strategy is not just patents. And the one piece here that you see already is this data exclusivity, the regulatory barrier. That's part of your strategy that still protects you. The fact that Novo was capable to pass that regulatory hurdle. It takes that expertise of their professionals to do that. And so that is part of the IP strategy, that are capable of doing that with a compound. And there's other elements of having a pharmaceutical compound on the market that Novo owns that might be trade secrets around how they exactly manufacture, the quality of their product, how they do their quality control. All those kinds of things, and even like their brand name, the fact that, when you go to purchase your medication, you'll prefer the Novo Nordisk variation that is made in the United States as opposed to in some other country where a generic might be manufacturing, and you don't know who the generic is, and you don't know the quality and the brand of it. So all of those things actually go into the strategy behind protecting the market.
Yeah. Thinking about your example where they let the Canadian patent, there you have it there, the patent lapse. I don't know what it costs to make this drug and what the market size is in Canada, but if a Canadian patent has lapsed, then that means whatever was covered by that patent can be done in Canada. But if it takes a big enough facility or scale that is only really worth making a North American production, and Canada doesn't have its own, then it's not as maybe profitable for a competitor to come in and start making just for Canada. And that might be how it's up. Now you say Sandoz and Apotex have entered, so they might think opposite. Well, we can start small in Canada because it's allowed there, and then when U.S. goes generic, we'll have an avenue, an infrastructure set up to then expand to that market. And so whether Novos, again, did it by accident or strategically, just because they don't have the patent in that country, they may have other supply chain reasons why they get some protection.
Yeah, and also Novo might be thinking they're already going to have the medication out in a tablet form. Nobody's going to buy injectable in the US and Canada. So if these people start to go and figure out how to scale up and manufacture and invest in manufacturing, they're going to leave them behind. Especially
they're only going to be able to make the older version of the injectable, and people will have already been converted over. So there's that whole complex calculation. We're going to assume that they just didn't leave it to chance, that they thought through some of that.
And then again, I'm pretty sure this current version that this patent covers it has to be refrigerated, so it's really not ideal if you're going to be making it for Canada in Canada.
Right.
Now you're going to try to take it to a market in China, refrigerated. That's you're really going to cut into your margin.
Mm-hmm.
What this means for any inventor: a single patent is a single lock. Thickets are built deliberately over years. Every new indication, formulation, delivery method is a filing opportunity. So, to think in layers, not in patents. And if you want to understand the approach of a company like Novo, you really need to look at what are they doing. And again, they're going to leave behind a clear mark because their patent applications will publish in 18 months. They do want to protect their innovation through patents. So you can pretty clearly investigate all of these things that we were just hypothesizing. One molecule gets you in the door, the thicket keeps others out. So come to us with your questions. We're happy to investigate the thickets of your competitors and your customers and uncover opportunities you didn't think of. Come to tornadoipconsulting.com and schedule some time. Thank you for listening. This is Thoughtful Thursdays. Happy to chat. If you want to email at info@tornadoipconsulting.com with other questions and topics we could cover, we're going to continue to discuss and make these available through our Substack.
All right.